For me, it just. Oh, never mind. I see. I think it started recording now.
Okay, perfect. Perfect. Well, do you want to get started? Do you want to wait a little bit more?
Sure. I think we can get started. It's
Okay,
recording.
sounds good. Sounds good. Then let's get started. Okay, well, welcome everyone. Today we'll be talking about estate planning for parents of minor children. And the focus is, of course, quite simple, but very important goal. And that's, of course, protecting your family's future. So, moving on. Danielys, would you tell us a little bit more about yourself?
Sure. Good evening, everyone. My name is Danielys, but I go by Danny, and I'm an attorney based here in Miami, Florida. And I help families with estate planning and immigration matters. I'm very passionate about making the law feel approachable and affordable to all families. And as someone who came to the US as a child myself, I understand how difficult it is and how important it is to protect everything that we have worked so hard to gain here in this country. And my goal is to help you protect your legacy.
Excellent, excellent. Well, very similar here. My name is Katya Kross. I'm a founder of Kross Law PLC, and I work in estate planning, of course, helping people take care of their families through wills, trusts, and all the legal stuff that can oftentimes feel so overwhelming. And I also practice immigration law, focusing especially on family immigration. And as an immigrant myself, I came to the US when I was 10. Like Danielys, I went to St. Thomas College of Law, and that's where we met. I also have my private pilot license. So when I'm not working, I'm usually in the air or planning my next trip. I speak Russian in addition to English, of course, and I'm trying to work on my French very slowly. And it's really a pleasure for me to work with clients from all different parts of the world. And I'm really glad that to be here today and that you guys are here today. And I'll do my best to make everything as simple and as easy to understand as possible.
Yeah, in law school, we bonded through trauma, so now we're stuck together.
Absolutely. Absolutely. That's the way it goes. Okay, so what are we going to be doing here today? We'll go over the basics of naming guardians, explain what the wills and trusts really mean for parents with young children, and we'll talk about simple financial strategies that could be potentially helpful, or at least how they can work with the wills and trusts, things like that. Our goal today is to give you a clear and practical tools. And at the end of this presentation, we want you to feel a sense of peace, knowing that you've taken the steps to protect your children if something ever happens. So let's first start with some reality, a little reality check, I suppose. What happens if parents don't have a plan? If there is no will, no guardianship papers, no trust, then the court steps in to make all the important decisions. Family members can end up fighting over who should raise the kids, uh, and or how finances should be handled. Everything will have to go through probate, a process that is public and quite expensive and often takes months, if not years. And while the judges typically do their best, they apply the law and not necessarily the parents' wishes. So the outcome may not reflect your values or your vision for your family or your children. The guardians for your children might turn out being family members that you personally would have never chosen yourself, or they might not be family members at all. So that is exactly why planning ahead for your family matters so much. So, our little roadmap for today. First, we'll talk about how to choose and name guardians for your children. Next, we'll cover the importance of the wills and trusts and why they're essential in protecting your young children. We'll also share ways to prevent family disputes and prepare for any emergencies. And finally, we'll leave some time for your questions so you can get answers to the issues that matter the most specifically for your family. So, first, let's dive into the guardianship process. This is usually the number one concern that parents truly raise with us. They'll say, "What if something happens to me? Who will be there to take care of my kids?" And that answer depends entirely on whether you've taken time to legally name a guardian or not. And indeed, one of the biggest heartbreaks that we do see with families is the families that didn't plan for guardianship, and then unfortunately something horrible happens, and the court has to be involved, and it turns into a very complicated, long process. So let's break this down further. First of all, if you don't name a guardian, like I've already mentioned, the guardian is going to be named by the court. That may sound okay, but it can create some major issues. Judges try to do what's in the best interest of a child, but without a parent's guidance, they're making that call without potentially having all the relevant information. And that can mean delays up to several months, where a child could be placed in a shelter or a foster family for this time. That can also mean some family disputes, sometimes the appointment of someone you never would have chosen yourself. And also, by naming guardian, you ensure continuity for your children. You can choose someone who truly, sincerely shares your values, your parenting style, and your vision for how exactly you would like to raise your children. It's certainly about avoiding the uncertainty, avoiding conflict, and making sure that your children are cared for by the people that you sincerely trust. So, one question that we actually get asked the most is how to exactly choose the right guardian. And choosing the right guardian isn't easy, but there are some key factors to consider. First of all, the relationship. Does this person have a strong, loving relationship, loving connection with your children? And are they willing to take the responsibility? Second, it's also important to think about the values and the parenting style. Do they share your outlook on education, discipline, faith, lifestyle, things like that? And third, it's also important to think about age and health of your potential guardian. Someone older may face health challenges down the road, while someone younger may still be figuring out their own path. And that's actually another part of the reason why it's also important to reconsider your guardianship plan at least once every few years, as things may change, kids get older. So that is certainly a big factor. Um, Now, there's also location. If your chosen guardian lives far away, that could mean uprooting your children from their schools and their friends. Also, of course, important to consider the potential guardians' financial ability. They don't need to be wealthy, but they should be financially stable enough and willing to work with a trustee if there's a trust if needed. And finally, always check with the person before naming them. Make sure they're both willing and able to serve as your guardian if something, God forbids, happens. No one really wants to be surprised about becoming a guardian. And also, just as important is to name a backup guardian. Life changes, and it's essential to have more than one option in place. So, we always try to make sure that there's a whole plan in place, right? So, if anything, there's a backup to a backup to a backup. Um, you never know what can happen, and it's important to be prepared for everything. There are also some common mistakes that we do see over and over, and one is not talking to the person first. Again, imagine if someone just surprises you by naming you a guardian, and you're getting surprised with all this responsibility potentially at the worst time possible. Another mistake is failing to name an alternate guardian. Like I mentioned, circumstances change and your first choice may not be available. So it's important to have a first choice guardian and then a second choice guardian if, God forbid, something happens. And then also, um, some parents assume that the court will just pick their preferred family member, but honestly, without legal nomination, that's absolutely not guaranteed. So it's important to actually make your wishes known if you want the court to actually follow what you want. We also see some issues when parents name co guardians, for example, a sibling and the sibling spouse. If their relationship changes or they disagree on a big decision, that can certainly lead to some big conflicts. Other mistakes include choosing someone without considering their health, their finances, or their ability to move. And finally, as I've also already very briefly mentioned, a big mistake is failing to update your choice over time. The person who made sense to be a guardian when your child was a toddler may not be the right fit for when your child is a teenager. And estate planning is not a one time task, truly. It should evolve as your family grows and as your kids become older. Situations change. So there's a lot of considerations that really come into play. And now, Danielys, could you tell us a little bit more about the wills and trusts part of the planning?
Yes, of course. Thank you. So now that Katya has touched upon the importance of naming a guardian and the common mistakes, I'm going to talk about the other end of estate planning, which is wills versus trusts. So I'm going to start. Let's let's really touch upon. I'm going to touch upon the key differences between the two. It's not going to be an in-depth comparison. That's why at the end of the webinar, you'll see that we're going to encourage everybody here that attended to join us in a private consultation. But I'll start with wills, basically. Um, and Katya, can you please move on to the next slide? Thank you. So unfortunately, because many of us don't know when our last day will be, and this is a very morbid topic that usually doesn't come up in parties. So estate planning, unless you really, unfortunately, unless you really need it or you're in an emergency situation, that's when typically people tend to look for an estate planning attorney. But because it is something that we can't control, this is actually why an estate plan is a necessity, not a luxury, as most people don't realize this when they come and see us. And here in Florida, your plan, and when you try to create your estate plan, it will either be centered with a will or a trust. A will lets you name a guardian, which is what Katya was covering. You can name in a will. You can name a guardian for your kids if something happens to you, and without one, the court, like Katya mentioned multiple times, decides. So the judge will decide based on all the evidence that's presented, what who will be the designated guardian for your child, and this may not be the person that you ultimately would have wished. Um, with a will, you also have control, some control, not as much as you will in a trust, but you have some control of how your assets will be distributed. And instead of relying on the default laws, which sometimes a will is better than nothing. That's the ultimate conclusion. A will is better than nothing, but it can be an issue because of probate. You still, you get to decide who receives what, but we have very limited guidelines, and this is why a lot of people ultimately decide on a trust, because the trust has more leeway on instructions that you can place. Next slide, please. True will, you can also create what's called a testamentary trust, and basically it's a built-in trust that manages any inheritance for your children until they reach a certain age. So if, For example, you don't want your children to get their money outright, which is often a concern for parents who wants your 18-year-old to receive $100,000 upon them turning 18. You can get around this with something that's what's called a testamentary trust along with your will. Which again, if you just have a trust, you might not even need the combination of a will and a testamentary trust, which is oftentimes why, again, parents just opt in for the trust and don't do a will. But it is an option. If you want to opt in for a will, you can also throw in there a testamentary trust. Um, you can also, with the will, you will have to name a personal representative of your will, and that's the person who will handle your estate. So you're basically picking someone, a very trusted person, to handle how your will is going to be managed upon your death. And by putting all of this in writing, again, you reduce the chances of conflict or confusion among family members. uh, Something that a lot of people often ask: does having a will prevent people from contesting it? Of course not. People can still, your family members can still decide to contest a will in court. Um, but it's better than nothing, and having it in writing is basically a guideline for the judge to determine, to hold a conclusion based on your wishes. Because if we just depend on Florida intestacy laws, the judge will really have nothing to consider. So a will brings clarity and is often the greatest gift that you can leave behind to your family members. Next slide, please. Okay, now moving on to trust. This is another way that you can protect your children and your family, and it gives you a little bit more control. Now, I don't want to make it seem like I'm pushing everybody towards creating a trust based plan. A will is also, it's an excellent option, is better than nothing, but there are and the reason why I highlight the benefits of a trust is because there's a misconception that people have that trusts are for wealthy people. And every time somebody hears the word trust, they think of an old guy, rich old guy, and that's really not the case. A trust is just as approachable to any family. It doesn't It's not just for wealthy families. A trust, similar to a will where you have a personal representative, in a trust, you can name a trustee, which is the person that's going to manage your assets. The difference is that trustee, while you're alive, you can name yourself the trustee of the trust, because a trust becomes per se alive the moment that you sign it and you fund it with your assets, versus a will only comes into law the moment that you pass away. Your family has to go through the probate process, so there's a key difference between the two. um, it also allows you to control when and how those assets are released. So in a trust, you can set more specific, it can be as specific as you want. And Katya and I would know because we create very, very detailed trusts, sometimes 80, 100 pages of people putting in instructions on how they want their assets released. A will is typically not that lengthy, not that detailed. It's much simpler, and sometimes can leave a lot of room for confusion in your family. Um, and it's just a great way to make your children, um, make sure that your children are well cared for, and that your wishes, that everything that you put in your estate plan aligns with your values, which is very important to most families. Next slide, please. Okay. Um, a trust also avoids the need for court supervision, which is the key difference between a will and a trust. With a will, your family members will always have to go through the probate process, which I know it sounds very legalese, very fancy, but it's just another term for your family has to go to court. And no one likes to go to court. No one, unfortunately, as much as I love being an attorney, as hard as it's been to get my license, nobody wants to hire an attorney when it's unnecessary. And that's what Katya and I try to do when we help families and we try to build you an estate plan, is we try to make sure the best that we can that your family doesn't have to end up in court because no one wants to go to court. Um, Without an estate plan, the court may have to appoint again someone to manage your child's inheritance. Some may not be the person that you want, and sometimes that person ends up taking advantage of the power that they have over your kids' assets. And having a trust also adds a layer of protection against creditors, which is something that a lot of people don't think about, or even divorce, because if your child or eventually adult child ends up getting married and then divorces, your the spouse of your child might end up with half of their inheritance. Um, Also, if you become incapacitated, a revocable living trust ensures that your assets can still be managed immediately by your chosen trustee without any delays, and again without having to go to court, which is the key difference with a will. You can't really do A will doesn't plan for an instance of incapacitation. So if you're in an accident, if you're at the hospital, you're still alive, but you're not able to manage your assets and decide who in that instance who's watching out for your children. Next slide, please. And here's a quick comparison between the two. A will only becomes effective after that and always goes through probate. You always, which a lot of people are surprised about that. A lot of people think that if you do your will, that's it. No court involved. You're done. Everything's clear and set. But that's really not the case. The only way really to avoid court is to do a trust-based plan. If you don't do anything at all, which is what people ask, well, so if a will makes me is still gonna make my family go to court, why don't I just depend on intestacy laws? I don't want to do anything. I don't want to spend the money. Well, if again, if you depend solely on the state's laws, some people might end up with your assets of people that you, for example, there's a lot of people who don't marry nowadays. A lot of couples who are together but then never marry. If you don't do absolutely anything, your life partner is gonna end up with nothing, because if you're not married in the state of Florida, then the intestacy laws is gonna give your assets to a whole another person. So that's a big issue. We don't want to rely on intestacy laws. And then a will, you're always gonna have to go to court. You're always gonna have to spend that extra money on attorneys, that extra time going to court. So the only way that you can really avoid court is with the trust, which a lot of people are surprised about that. The trust is effective upon of the moment that you sign it and you fund it. So it's different than a will. A will is simpler. We can give it that pro. It's much simpler to draft. It takes less time. It's a little bit it's less expensive, but it's expensive upfront. So the moment that you're drafting it is less expensive, but the problems that it's gonna cause, it's at the end of the day, you're probably gonna save more money by just doing a trust to begin with. Um, and our estate plans, so the estate plans that Katya and I make, are really centered either on the will or the trust, and then they are combined with a different set of documents to make sure that you're as protected as possible. We include in our estate plans powers of attorney, which is you're basically making a clone of yourself. You're giving somebody else ultimate power over your assets. That's the person that can go to the bank and take out money of your out of your bank account. Um, we also provide a living will and a healthcare proxy document, which basically you're gonna put in those documents what healthcare you wish to receive in case of an accident, and which ones you don't. Do not resuscitate, things like that. And a healthcare proxy, you're basically gonna give that power to make those medical decisions to a person, your mom, your spouse, whoever you want. And then we also create the pre-need guardianship designations. You can designate a guardian for yourself, for your kids. So our estate plans are not really just one document. We center or we pick a will or a trust, and then we center our plan around that document.
And I think we have a poll,
Mhm.
right, for to see what is the preferred will to a trust. What how do our participants feel about it?
I hope I didn't push them towards the trust. I was trying to be unbiased.
Well, to be fair, the trust it just makes it a little bit more flexible. So, okay, looks like we have 50-50.
Yeah. Yeah,
So,
'cause don't our clients love to also ask the question, which one will you pick for your estate plan? That's usually a question that we get.
absolutely. Absolutely. Okay. Oh, I think we're encountering a little bit of technical difficulties with the presentation. It's coming back, um, but yeah, no, definitely, definitely, very commonly asked question in terms of which one we would go for. Um, okay, so talking about questions, some commonly asked questions are on the screen. Can I change my guardian choice later? Danielys, do you want to take that one?
Yeah, sure. You definitely can. So if you initially name someone as the guardian for your kids, and then you end up finding that they're this wicked, horrible person, you can definitely you can definitely um change up the guardian designation. As long as you're of able state of mind and your life, you can change your document. So as soon as you find out that that person's terrible, make sure to call your estate planning attorney and change it up.
Absolutely, absolutely. Then we have another question. Does my designated guardian have to agree or be aware that I have named them? Um, well, I would say it's definitely very, very preferable. I there is if they are not knowing that they were named, that could be definitely an issue because they would find out about it in a very potentially unexpected way in a difficult time. So that's 100% preferable to at least to discuss it before actually naming that person. um, right? Do you agree, Daniellis?
I agree, and especially since you really never know if somebody's ready to take on that much responsibility or if they have the financial means. And it's an important conversation to have because maybe you want to designate somebody as your child's guardian, and you have a method. You're gonna make sure that they're if they're not financially able to take care of your child, then give them that peace of mind that you're gonna provide them with the financials. It's a huge surprise to get a call one day and be like, "Hi, you have been designated as a guardian for a child that maybe you weren't ready to take on." So I definitely agree.
Absolutely, it's a huge responsibility. So it's almost um, not very thoughtful. You have to plan. So
No, and sometimes we also have cases where there's two family members that really want to be named as guardians. So maybe the two grandmas really want to be named as guardians, and then you have to pick one. And it's important to establish that conversation within the family so that they are aware and the case doesn't end up going to court because of you didn't have that conversation as well.
absolutely, avoiding conflicts, that's essential. I see that we also have a question in the chat: how long it takes to create a trust? That's a good question. I would say it certainly at least partially depends on the complexity of your trust. All right. If we want to write very, very complex, detailed provisions, it's going to take longer. I would say the average for something not extremely simple, but also something not extremely convoluted would be about a month. That would be my approximation. Right? Would you agree?
Right, and oftentimes, believe it or not, it depends on the client. Depends how many changes the client wants. Sometimes when we're in the middle of drafting, the client decides to change all the terms, and when we had one beneficiary set, then the client will be like, no, I had an argument with my sister. Now she's no longer my designated beneficiary. I want to name somebody else, and then we have to change up the whole trust. So really, ultimately, it really depends on the client, and like Katya says, the amount of assets that person has. So sometimes something what seemed very simple in the consultation ends up not being very simple as we're drafting. So
Absolutely, absolutely. And then the whole other thing is we have a very specific process in that sense, like there's we do first just the, initial consultation, then we do our design meeting, which is where we meet and we actually discuss everything that you want in your estate plan. Then we actually draft it. Then we do another meeting to actually go over your whole plan with you, and then after we only after all of that we do the signing. So it also depends, I would say, on the availability of the clients and actually coordinating the schedules and things like that. So that impacts the time too, but generally I would say it's about a month maybe. So, and then I see there's another question: and how often do I need to update the trust? What would you say, Daniela?
how often we would need to update the estate plan? As we normally it's recommended that once a year you meet with your attorney. At least the first year that you do your estate plan, the following year we offer a free follow-up consultation with our client. And then as often as something major happens in your life, so if you divorce, if you marry, if you have another baby, if you buy a ton of property, if you win the lottery, something like that. So if something major happens in your life, then it's definitely time to update your estate plan. If you end up wanting to change who your beneficiaries are, so if you have a fallout with whoever you left as your beneficiary, it's time to change up your estate plan. So it's really, I guess it's really a question of, again, of it's up to the client. So it's up to you. You'll know when something major happens in your life that you'll need to come back to us. But the year after we provide you with your estate plan, at least Katya and I, we do provide our clients a free follow-up meeting a year after.
Yeah, because also a lot of things can change even in that one year. You also finally receive your plan. You kind of have time to very carefully, you're supposed to read through it even before, but you also have some extra time to read through it another time and think through and see maybe you want to make a little change, something you didn't think about a year prior. So, and then of course, like we were mentioning prior, as your children grow, um, you might want to make different decisions, so that impacts it too. And then our other question was, which documents are most important if I'm just starting? What would you say?
Definitely are either a will or a trust. And in case of incapacity, then the other ones that I mentioned, the power of attorney, which allows somebody to step in and take care of your assets in case you're in the hospital in a coma. And the healthcare directive and the living will, I also would say, are very important, because if you're in a um, life or death situation, and you have your family having to make a very difficult decision, you might have, for example, your spouse and your mom not agreeing on disconnecting you or not agreeing on giving you X surgery. So if you put in a document who gets to make that decision, you're also going to avoid your family a lot of headache in case of an emergency. This is something, I mean, estate planning is something that a lot of people don't want to think about. They don't want to picture themselves at the hospital or dying, but it is extremely important. It saves so much peace of mind to your family, even to yourself, just knowing that everything's already laid out in paper.
Absolutely. Absolutely. I completely agree. I would just re-emphasize one more time the importance of the actually choosing your guardians ahead of time, especially in case of incapacity, things like that. The pre-need guardian declaration. We actually get a lot of clients who come to us initially just for this one specific document, just because of how truly important it is. So it's essential, especially if you have minor children. Um, okay, so please, anyone, feel free to book your consultation with us. We would be very, very happy to talk to you specifically about your situation, how we can help specifically you taking into consideration uh, all of your family, your specific wishes, desires, concerns, things like that. And you have a QR code on the screen right now to sign up, and would be happy to talk with you one on one.
Yeah, and just to add to that, the consultations are completely confidential and private. So sometimes in the consultations, or oftentimes, we cover very difficult topics, a lot of drama sometimes, and it gives the clients peace of mind knowing that it's no one will have, what's we speak in the sessions stays in the session. So what happens in Vegas stays in Vegas. What we speak in the session stays in the sessions. So you can feel completely comfortable. You can think of us as your private therapist as well, because we kind of are. Oftentimes we are therapists. So and I don't know anything else to add, Katya.
No, no, I completely agree. Maybe the only thing is the consultation itself is free, at least right now, as per what we're doing right now. So you're really not losing anything. If you just sign up, we're just going to have a conversation, kind of give you a better overview of your situation. And if you feel like you're good with how things are right now, then that's great and that's absolutely fine. And if you want to speak to us, learn a little bit more about specific forms, or maybe just a preneed guardian declaration, or maybe a will or a trust or anything at all, the living will, healthcare surrogate, all those little forms. That is fine by us. We're here to help however we can. So um, yes, and thank you for everyone who came to be with us tonight.
Thank you, and everybody have a wonderful night. Thank you for taking a little bit of time on a Thursday night before a long weekend to be with us. We really appreciate it.
Thank you. Have a good one.